Janet?
Thank you. Sorry, it's a bit high. Thanks very much. I was asked to deal with a number of questions, but I thought the way in which I would tackle the subject would first be to look at the transitional justice mechanism in South Africa, and then the way in which that did or didn't impact on the actual transition, and how the system of justice maybe is more embedded in the success of the transition going forward. The transitional justice mechanism in South Africa has been written about a great deal, and in many instances portrayed as some sort of miracle in the form of the Truth and Reconciliation Commission. As somebody who was in the parliament that passed the legislation on the basis of which the Truth and Reconciliation Commission carried out its work, I have to say my views of the subject would be much less complimentary. I think that the TRC process was premised on the notion that there needed to be not just an opportunity for the retribution, and that would need to be based on the system of justice that we have in South Africa, but there needed to be an opportunity also, so the two were not, there was no exclusion of one in favor of the other. The system also needed to make available opportunities for people to reconcile. And the basis of that reconciliation was going to be, is supposed to be a disclosure, a full disclosure of what transpired. I think that in the process, the TRC managed to achieve some of those objectives, and I think that it was certainly an important part in enabling the society to go forward with the project of establishing a democratic state. But there were a number of difficulties. First of all, there are huge limits that existed to ensure that people were able to back up the idea that they had not received full disclosure with any kind of evidentiary basis. So, just by way of example, there were various distortions about what happened to individuals, which have subsequently, many years later, through the excavation of bodies and forensic evidence, proved to have been, after the fact, not a full disclosure of the events that took place. And obviously, within that process, as much as there were a number of examples of people who came to the TRC process with a level of commitment and sincerity that I think was truly remarkable, and definitely did help a nation to come to terms with a very problematic past. The reality is that that experience has not been the experience of many in South Africa. There are also a number of instances where there was no even half-baked attempt to come forward with information that pertained to the fate of individuals. There are people who still are very much within the category of the disappeared, and about whose fate very little is known. So I think that the experience of the TRC from the point of view of truth disclosure was partial, but nonetheless the truth that was exposed, I think, was very, very critical to enabling the nation to come to terms with just recognizing its past. So that part of it I actually don't, I think really did have some huge success. But of course, the issue of the TRC was that even if reconciliation was achieved, there was no basis, there was no requirement or no obligation that a fully reconciled victim-perpetrator situation would preclude any action being taken through the courts. And indeed, actions have been taken through the courts. And I think that this is really where there is an indication of real problem with some of the issues, because firstly, court processes are very long. Secondly, court processes require a body of evidence beyond any form of reasonable doubt that is very often difficult, if not impossible, to achieve in a situation where officers of the apartheid regime had many months to have the shredders humming, who had many months to disguise and create and fabricate, so that you have people whose actions are part of the history of our country. For example, if I think of the scientist Basson, whose engagement in the creation of poisons for the Defence Force is well documented, and yet his direct involvement in the use of any of those materials was not in the end possible to prove in a court of law in South Africa. In Namibia, his day of reckoning has not yet come. But I think that so the reality is that the possibility for court processes to take place is often very limited, and it's very time-consuming. And I think that I'm not going to go into a whole lot of other issues of comparison, but I think that that is one of the things that certainly in Rwanda has been a real concern for the people of Rwanda, is that if one is going to actually put up a court process in Rwanda which deals with the atrocities that were committed and the people against whom evidence exists, one would probably finish the casework in around 90 years' time. And I mean, that's actually been quantified. So we can see that there are some serious problems. I think the other thing with regard to the transitional justice mechanism in South Africa that was deeply problematic for a number of people was the fact that it was based on a premise that the actions that were undertaken in pursuit of racial hegemony of whites and racial discrimination were akin and on par with actions that were carried out in the pursuit of democracy. And I think that has remained something that is very, very problematic for a number of people. So that was the transitional justice process as it unfolded in the TRC period. But what, of course, has become even more problematic is that part of that process was for a level of restitution to take place in the wake of the closure of the commission. And that restitution has not, in fact, been implemented, certainly to its fullest extent, but in addition to that, there were huge delays in any implementation, and of course that too has had a very negative impact. What the TRC process did, as I say, on the good side, was that it enabled a level of truth, a level of discourse, a level of dialogue, in addition to some reconciliation, to be achieved. On the other hand, what it did, aside from giving a number of people a sense of deferral of justice, it also, I think, created a situation where there was an illusion for a time that constituted a basis for people to go forward in racial happiness and harmony and into the deep sunset. And the reality in South Africa is very different. You know, transition in South Africa, just like in any other country, including the United States and anywhere else, is going to take decades, is going to take generations. And the dynamics that exist in South Africa today are still based on the deep divisions at an economic and social level that prevail within that society. All of the obstacles to the overcoming of poverty that have been documented by a huge range of authors, not least of which is ODI, exist in South Africa. And I can come back to commenting on some of those. We're not a poor country. We're certainly not a poor country. We're just a country that has huge imbalance and inequity in the distribution of wealth, and that has still remained. So these are things that I think become a continuous challenge. Now, how does this kind of tie into the whole notion of justice? I've mentioned the transitional justice mechanism, and as I say, I think its impact is mixed. My criticism shouldn't be understood as saying that it has had no value. It has had tremendous value, but it has tremendous weaknesses. But if one looks at what really brought around the transition in South Africa and what reflects too the fragility of that transition today, it's the creation of our justice system. It was the creation of our Constitution. The Constitution was a document that saw the participation of a nation in the drafting and writing of that Constitution like few other processes in the whole of history, I think, have witnessed. The document itself was infused with over 2 million inputs from individual citizens, that teams of people looking at individual rights within the Constitution, looking at individual chapters within the Constitution, were obliged to actually discuss, debate, and take expert opinion on huge piles of documents on each and every right. The whole way in which that document was then discussed and promoted and checked by our own constitutional court against the principles of our transition and struck down on the first occasion, was something that I think gave the nation a level of confidence in the judicial process, as well as in the strength and power of the document that they had participated in drawing up. And I think that was a huge part of our transition. It dominated the discussions that were around the CODESA through to the Transitional Executive Committee. It dominated those discussions, our so-called peace discussions. But it also then dominated the discourse because our Constitution, unlike I think any other constitution actually, specifically requires the judiciary to look at every aspect of matter that is brought to it in the context of the obligation of the Constitution. The Constitution obliges that transformation must be effected in its implementation. Transformation from an apartheid and undemocratic past to a kind of future that South Africans want to enjoy. So, to me, the justice system, as created, the institutions that are created, the checks and balances that are created in our Constitution, lie at the heart of our transition. And equally, they lie at the heart of the fragility of that transition. Because it is the whole question about the rule of law, the independence of the judiciary, and the understanding of the need to still infuse in the nation on an ongoing basis the values and principles and rights contained in that constitution, that it is those things that are really underscore what is fragile about the transition within South Africa. Just to wrap up, there are a couple of things that I wanted to comment on, and I certainly don't mean to do this in any way of dealing with the whole issue of the international role. But it seems to me that the international community, in its understanding of its role of international justice, has possibly only understood it in the context of criminal issues and of retribution, and has not understood its role in the significance of the promotion of human rights. And it seems to me that that is part of the questioning that is, and it's not to replace any of the comments that have been made by Nick in terms of other questions that have been raised, but it's certainly a big part of the questioning. The second thing, and that's really my concluding remark, is that I think that we need to ensure that the way in which we understand the whole notion of achieving a social order in which the kind of poverty and deprivation that affect so many in South Africa will no longer exist, we have to see that development discourse as something that is integrally linked to governance and the fulfillment of rights. The minute we try and separate and create silos about that is the minute that we actually spend too much time on a kind of artificial way of understanding the challenges that confront us, and the sort of justice that is not necessarily only retributive that we need to pursue, but a justice that is preventative and also promotes the kind of rights and transitions. Thanks very much.